they're not much use if you can twist them and turn them and interpret them so that what is happening in the world today can somehow be presented as in compliance because you've got a particular interpretation.
No one can act with impunity.
These are crimes that are beyond the pale.
We are talking about human beings. We're not talking about numbers.
We need a court. That's as simple as that.
This is Asymmetrical Haircuts, your international justice podcast with Janet Anderson and Stephanie van den Berg.
All rise.
Hi, Janet.
Hi, Steph. I can't quite believe it, and I'm not sure if you can either. We are here in Geneva when we're making a podcast about the Geneva Conventions with the Geneva Academy. It's all rather meta, isn't it?
Yes, I expect that the ghost of some very important founder of the Geneva Conventions, Henri Dunant, or somebody like that, as we are in the Parc Monnier, named after Gustave Monnier, also a Swiss jurist. But these are also both men now seen in a kind of different light, not only as important legal founders, but also as massive colonialists.
Yes, I mean, that's one of the issues that we have to deal with in our world, is that our continual reframing of who is who and why things were framed in the way that they were at the time. But do you think in this a little bit echoey space, are these ghosts kind of shaking their fingers at us as interlopers saying, you're journalists, you don't understand the subtleties, you don't understand the beauty, the elegance of this city and the elegance of the conventions? Or are they sadly shaking their heads saying realpolitik should trump idealism?
I really can't speak for the founders of the Geneva Conventions, but nevertheless, we are here and invited by the Geneva Academy of International Humanitarian Law and Human Rights to jointly make a podcast with them for the 75th anniversary, no less, of the Geneva Conventions, the ones that we always get thrown in our face and always get told that something must be or must not be against the Geneva Conventions.
Yeah, cue big trumpets or not, because these are really substantial issues that we're going to discuss. But actually, we've got some lovely colleagues here who've kind of smiling away at us and wondering how this is all going to go, wondering when we're actually going to get started. So maybe, though, typically we could do a bit of stiffopedia. If you use the term Geneva Conventions in a Reuters story, Steph, what's the journalese? What are they?
I've described this as internationally accepted rules of armed conflict emerged from the 1949 Geneva Conventions, which have been ratified by all United Nations member states and supplemented by rulings at the International War Crimes Tribunals.
Well, I think they're going to disagree with that. I can see that already from our experts. No, we've got that wrong. So I'm sure that will come up. So let's lay out the land here. We've kind of pre-prepared, oven-ready a set of charges, and these are divided into three sets of facts or rough descriptions, three counts against the Geneva Conventions. And we have two very distinguished guests. So let's welcome Andrew Clapham.
Oh, thank you very much for having me.
And Gloria Gaggiola.
Hello, everyone. I'm pleased to be here with you.
And for those who don't know, Andrew is Andrew Clapham, Professor of International Law at the Graduate Institute, and he was the first director of the Academy. He has worked as a special advisor on corporate responsibility to High Commissioner for Human Rights, Mary Robinson, and advisor on international humanitarian law to special representatives of the UN Secretary General in Iraq.
And Gloria Gaggiola was also director of the Geneva Academy and is now an associate professor and vice dean of the law faculty of the University of Geneva. And she was a legal advisor in the legal division of the International Committee of the Red Cross, the ICRC. So, how are we going to do this?
Well, we're going to read out the first charge against the Geneva Convention and then ask our guests to counter the charge or possibly agree with it. In this scenario, we are the prosecutors or the investigative judges, maybe in the civil system, and we are asking our experts here to give us their views. It's all a bit rough, but you have to kind of use your imagination. Here in this room, we have a small audience who are listening intently, and we will ask them in the end for a verdict.
Let me just say, though, this is all, it sounds a bit of a game, but this is all very important. This is one of the major debates that we can see going on in the world at the moment, that whatever guidelines the international community thought that it was setting up 75 years ago, for many people, they are not working. When we consider Sudan, Israel, Palestine, Ukraine. The world is on fire, and Geneva is apparently not helping to put out the flames.
But before we start, let's borrow the style of our colleagues at the Call to the Bar podcast for our academics here. This is not noted nor peer-reviewed and shouldn't be taken as representing the final word. Let's go now to our first formal charge in this mock trial read very kindly by Francesco Romani.
Considering that civilian deaths in our conflict have increased by over 70% in 2023, medical workers, humanitarian actors, as well as journalists are increasingly exposed to acts of violence, and conflict-related sexual violence has increased by 50% in 2023. The Office of the Prosecutor charges the 1949 Geneva Conventions with count 1, failure to protect victims of current armed conflicts.
So, what say you, Gloria, to this charge?
I say this is the most unfair charge I have ever heard of. I mean, you are accusing the Geneva Conventions not to protect civilians. This is absolutely ridiculous. After the Second World War in 1949, the objective was precisely to have a new convention, the Fourth Geneva Convention, that protects civilians in occupied territories, but also on the territory of the belligerent parties. So this is totally unfair. Then you speak about the protection of journalists, humanitarian workers, medical workers. I mean, there you have even a special protection under international humanitarian law. So you have this very strong obligation to respect and to protect these individuals because of the importance that they have.
Okay, yeah, you're right. It might be ridiculous, but nobody is paying attention to these Geneva Conventions. They might be written down, but in the wars, people are still attacking civilians.
But how can you accuse a text which tries to protect from being violated? It's as if you would be saying, well, this lady has been raped, that's her fault. And this happens in reality as well. So that's the same with the Geneva Conventions. It is for the belligerent parties to respect them, and it is for the international community as a whole to do everything possible to ensure respect with international humanitarian law.
So you're saying the one that should be in the bench of the accused is not the Geneva Convention, but the international community or the belligerent parties that are not following it.
Absolutely. Yes.
I think she's right. I think you have the wrong accused in the dock, Madame le Juge, Madame
But that's
Prosecutor.
what every war criminal I've ever seen on trial says. It's not me, it's that other guy.
But we plead the same. It's a misidentification. You can't accuse a treaty of committing rape and attacking civilians. It's the states what done it. It's the parties, it's the armed groups. All of those people should be in your court being accused of violating the Geneva Conventions. Our conventions set out the standard. They violate us. Now, there's another group of people I'd like to see in the dock here, Madame le Juge, Madame Prosecutor, and that's those states who are arming the parties and helping them, facilitating them to commit violations of the Geneva Conventions. All of those states, all of those arms manufacturers, they're complicit in this. So I'd like you to expand your vision as to who should be accused, including the states, the armed groups, the individuals, the states that are arming, and the arms manufacturers themselves.
If you look, though, if you have this convention set up to protect civilians, it's obviously not doing that. Should there have been more criminalized in the convention? We have the Geneva Convention, but we have kind of no...
They're a bit sparse, aren't they? I mean, they do a bit of civilians, they do a bit of medical workers. I mean, do they do enough?
Well, they could do a little more in a couple of areas, it's true. But I think it's maybe not what you're thinking of. I think the Geneva Conventions, or maybe a new text, could make it clear that nobody has immunity from prosecution. There's an idea going around that even if you violate the Geneva Conventions, as long as you're a head of state or you're a state official, you have some sort of immunity that international law gives with one hand, creating a violation of the Geneva Conventions and a war crime, and then it says, actually, it doesn't apply to you because you're a head of state or a state official, and you can't be prosecuted in national courts. So if you're asking me, could we do more? Yes, I think we have to get rid of immunity. And I think we could be also a little less reliant on the International Criminal Court. I mean, they're trying, but they're only going to be able to deal with a handful of cases. And there are all kinds of maneuvers to avoid getting prosecuted in that court. Every state in the world, every court in the world should be thinking about prosecuting people for violations of the Geneva Conventions. And somehow, and here I'm edging towards slightly agreeing with you, the Geneva Conventions could do a little more to bolster the idea that there's universal jurisdiction and every state in the world has an obligation to prosecute those who are accused of violating the Geneva Conventions where this constitutes a war crime.
But there is universal jurisdiction for grave breaches that is already enshrined in the Geneva Conventions. So, I mean, that's for the states to make sure that they are going to prosecute each time grave breaches have been committed in the framework of an international armed conflict. Unfortunately, many states just don't do it. In Switzerland, we are very happy because indeed we do have universal jurisdiction, and we have a beautiful NGO which is called Trial, which is precisely trying to prosecute, to encourage the prosecutions of war criminals that are coming in Geneva and in Switzerland.
So I saw you carry around a copy of the Geneva Convention. So
Absolutely. I always have my Geneva Conventions with me.
I have one of those with the Rome Statute next to my desk, but I'm wondering where in the Geneva Convention does it enshrine universal jurisdiction? This is an honest question because I don't read through the Geneva Conventions on a daily basis. So is it really, there must be universal jurisdiction?
Absolutely. At the end of each and every Geneva Convention, you have a provision on grave breaches with the obligation to have universal jurisdiction for those very serious violations of international humanitarian law committed in an international armed conflict.
Sorry, just to be clear, because this is an important point, it's not just that it allows you to prosecute, but it obliges you to arrest and prosecute. And you don't need to have had some arrest warrant from the International Criminal Court come down, with all respect to those who come from The Hague. This is Geneva law. It applies everywhere instantaneously. So as soon as there's an allegation against Benjamin Netanyahu, every single state in the world has an obligation to arrest him. It's written in the Geneva Conventions, irrespective of what happens in the ICC.
Is there anything specific that you want to pick out from these several different allegations against the Geneva Conventions that you think was particularly egregious?
Yes, indeed. There is this accusation that the Geneva Conventions do not really cover the issue of rape and conflict-related sexual violence. And it is true that when we read the Geneva Conventions, we realize that they are, let's say, a product of their time. So the wording that is being used is peculiar. However, we do have a number of provisions that prohibit rape and sexual violence. So you have, for instance, an explicit prohibition of rape in relation to civilian internees, women civilian internees, in the Fourth Geneva Convention. But you have also other provisions which more implicitly prohibits conflict-related sexual violence, because those violences amount to torture, inhuman and degrading treatment and punishment. It's an attack to the honor of the prisoners of war and of the civilian internees. So, of course, the terminology used is a little bit euphemistic, but in the end, those crimes are already considered as such in the Geneva Conventions.
But then you get also in the discussion of that for a long time, wartime sexual violence was slotted into other categories, like not just for being rape, but for being torture. And there was a big movement to have it specifically called out for what it was. And you see that now still. So it could be updated.
Yeah, it has been already updated with the additional protocols to the Geneva Conventions, which provide for several provisions dealing with rape as such. So look at Article 4 of Additional Protocol 2 on non-international armed conflicts, for instance. It provides for this fundamental guarantee of the prohibition of rape.
Let's move on now and let's get Francesco to read out count number 2.
Taking into account that the 1949 Geneva Conventions were adopted in reaction to the atrocities committed during the Second World War, that the great majority of the rules in the 1949 Geneva Conventions apply to international armed conflicts, whereas the majority of ongoing conflicts are non-international ones, and that new technologies of warfare pose specific risks, in particular to civilians, the Office of the Prosecutor charges the 1949 Geneva Conventions with count 2, failure to meet the challenges posed by contemporary and future armed conflicts.
Not guilty. The Geneva Conventions contain very detailed rules about non-international armed conflict. And this problem that, well, there's more rules for international armed conflict and fewer rules for non-international armed conflict is a false problem. It's a doctrinal problem that people focus on. But in fact, what you need to tell me is who is not being protected in a non-international armed conflict by the Geneva Conventions? What's the problem? To talk about it as a theoretical issue, to say, oh, it doesn't address non-international armed conflict, is misleading, and it sort of undermines the thrust of the Geneva Conventions. As my colleague has just said, in 1977, there was an additional protocol added. So even if the amount of information on violations of the Geneva Conventions is minimal in 1949, by 1977 we have a much longer list, and we have a long list of customary protections. So it's true that the conflict in Sudan is not an international armed conflict like the occupation of Palestinian territory or the war in Ukraine. But Sudan has ratified this protocol. So it's a false problem. If you want to protect people in Sudan, you use the 77 protocol. You don't use the 1949 Geneva Conventions necessarily, because you don't need to. It's a false problem. The idea that Geneva is stuck in 1949 is false. We have 1977. That's where we are now. And now in 2024, unless you can show me some deficiency in the 1977 protocol, I would say the Geneva Conventions are not guilty as charged.
Agree?
Fully agree. And I would say that, introducing Common Article 3 in the 4 Geneva Conventions, which is the only provision protecting individuals in a non-international armed conflicts with the Geneva Conventions, was already a revolution. Can you imagine how difficult it was to convince states to integrate in the Geneva Conventions some protections for non-international armed conflicts? Traditionally, this was understood as the domaine réservé of the states. They didn't want to have others looking at what was happening in civil wars. So it was already a revolution to have Common Article 3. So think about Common Article 3 as a little door that was created. And then, thanks to Common Article 3, we have had the opportunity to broaden that door through customary law. So now most of the rules of customary law cover both international armed conflicts and non-international armed conflicts. That is true today, but it wouldn't have been possible without the entry door that was provided by Common Article 3. This is also true when you look at the jurisprudence of the ICTY, the famous Tadic case. What could have done the judges of the ICTY without Common Article 3? It would have been very difficult for them to say that there are war crimes being committed in non-international armed conflicts as well. So it was really a crucial entry door, this Common Article 3. It's thanks to the Geneva Conventions that we do have rules protecting individuals in NIACs.
We should probably try and respond on the technology point.
That's exactly where I wanted to turn to
Andrew.
We
did hear you, madam. Yes.
Yeah. This is something maybe it's a panic that's going on around the world, but there is this sense that artificial intelligence is here, that there are possibilities of different kinds of weapons which could be targeted by non-human beings in some way. Maybe we've already seen some of that in Israel-Palestine. We don't know. But there's this sense that somehow we are not up to date enough to be able to deal with this.
And I think you have a point there. Probably the solution, though, is not in trying to amend the Geneva Conventions, because civilians should remain protected, but by having some sort of new instrument which prohibits or limits the extent to which non-humans can take these decisions. So first of all, on the technology side, recently the states parties to the Geneva Conventions were meeting here in Geneva, and they did actually take a decision that they need to address attacks on the infrastructure for the internet. So there's some debate, as if you're going after undersea cables that allow people to communicate in a technological way, as to whether or not that sort of thing is protected and so on. So one needs some extra protection that obviously Gustave Moynier, in whose house we are, and who wrote the first Geneva Convention, probably where both of you are sitting now, because this was his study. He wrote it in 1864, so you're sitting in the seat that wrote the Geneva Conventions. And of course, he didn't have the internet at that time, and he didn't have this problem of artificial intelligence, and it's not in there. And I would be the first to admit that some of these machines are not capable of determining whether or not the damage to the civilian population is excessive What does that mean for a machine, excessive? How can we ask somebody to make a value judgment like that who's not got children in the school that's about to be bombed or in another school that might be bombed, and to be thinking about the human effects? They can't do it. And in that context, I think there's plenty of room to start to prohibit and limit the extent to which technology can take decisions which could indeed violate the Geneva Conventions. But I wouldn't look for the result within the Geneva Conventions.
Why not?
I mean, are you aware of the principle of non-retroactivity? How can we think that the drafters in 1949 could know that there would be, lethal autonomous weapons being developed, cyber warfare, artificial intelligence? It was not possible to imagine this at the time. And still, they thought about this possibility that the Geneva Conventions would not be completely comprehensive. So you have this magnificent clause, which is called the Martens Clause, which refers to the fact that even if something is not covered by the Geneva Conventions, you still have the protection given by the laws of humanity and the dictates of public conscience. So even with this Martens Clause, we can see that there are certain elements of law and ethics that can sometimes restrict the new methods of warfare.
So they have prepared for unknown unknowns.
That's right, exactly.
One thing that I was wondering about is when you see reports of the International Committee of the Red Cross sort of saying, let's update, let's look at what's going on, and they start to talk to Beijing. So they're dealing with an authoritarian regime that is under huge criticism for human rights abuses. And yet they're saying, can you help us look at this treaty and maybe update it? Doesn't that kind of smack a bit of hypocrisy?
Absolutely not. I mean, the whole idea of international humanitarian law is that we want to have rules that are as universal as possible. So this is the core, the essence of international humanitarian law. It's being as universal as possible. So of course, you do want to have all the states around the table discussing the possibility of developing new treaties, not reopening the Geneva Conventions, because that would be a suicide. Given the state of the world nowadays, I'm sure we would not be able to reach the same level of details in the rules. But certainly we could have a new treaty on lethal autonomous weapons, and we do want to have states like the US, like China, which are precisely developing those technologies to discuss and to try to lead them to regulate those means and methods of warfare. It won't be easy, but we have to try.
But then if you want to keep it as universal as possible, and we see that now with the Geneva Conventions, Israel says they are abiding by international humanitarian law. The US says the same, and they have Guantanamo still operating. If you can interpret it as widely as being done now, does that not defeat the purpose somehow? If you have it this wide that people can say that they have some plausible explanation of why they are adhering to the Geneva Conventions when a lot of people would say they might not be?
I think you make a very good point. They're not much use if you can twist them and turn them and interpret them so that what is happening in the world today can somehow be presented as in compliance because you've got a particular interpretation. And I would say that is why we need institutions like the Geneva Academy that can stand up and say, you've got the interpretation wrong. You can't say that destroying that apartment block is proportionate civilian damage because you think there's one person hiding in a tunnel somewhere nearby and 80 people die. That is not in compliance with the Geneva Conventions. Now, states don't want to do that because they have foreign relations, they have commercial relations, they think that they might want to do it in a future war. So somebody has to interpret the Geneva Conventions and call people out when they're violating them. And it's quite a small gang of people who are ready to do that for political reasons and for expertise reasons. Historically, human rights groups have not got into the business of determining whether there's a violation of the Geneva Conventions. They're doing it now. And there's pushback from states who say, well, you're a human rights group. We don't have to listen to you. We'll listen to the ICRC. And the ICRC will say, well, we'll raise it with you privately, but we need to continue to have access to that area to deliver water and assistance and visit the prisoners of war. So we're not going to make a public statement that this isn't the correct interpretation of the Geneva Conventions. So it's a real problem, what you've identified.
What's the solution? I mean, has it got to be sort of immediate court cases?
Well, court cases can go some of the way to clarifying this some of the time, but we're talking about a handful of possible people possibly being prosecuted in the next few years. Nobody's been prosecuted yet for what's going on in Gaza. There have been some prosecutions with regards to Ukraine, but it's not going to change behavior on the ground. So it's a massive work of education of the troops, of the commanders, of the people who are funding and supporting their troops in war, to realize that not only is some of this completely illegal under the Geneva Conventions, but it's immoral, and that they shouldn't feel comfortable supporting their government in doing something which is clearly unethical, unmoral, and unconscionable.
I think this merges kind of into our third charge. So let's read out the third charge and see what our guests think about that.
Given that the vast majority of ongoing conflicts have been raging for decades, that violations of international humanitarian law occur in plain sight and remain often unpunished, and that the prevailing impression that a conduct does not amount to a war crime is lawful, or at least not prohibited under international humanitarian law, the Office of the Prosecutor charges the 1949 Geneva Conventions with count 3, complicity in the misconception of international humanitarian law.
Well, thank you, Francesco, for that third count. Oh my God, are we also misconceived? We don't understand international humanitarian law? Gloria, are we the ones who are wrong?
I'm afraid, yes. Because actually, who can end a protracted armed conflict? I mean, we do all agree that there are a number of protracted armed conflicts. Think about the occupied Palestinian territories. They have been occupied for more than 60 years now. You can think of even the conflict in Afghanistan, which has not ended despite the fact that the US withdrew. Think about the conflict in Syria, which started 2011. So yes, there are protracted armed conflicts. I don't contest the facts. What I'm saying is that it's not the Geneva Conventions which can deal with the end of an armed conflict. They cannot end an armed conflict. It's as if you would conceive the Geneva Conventions as the rules of an awful war game. They give you the rules, but they don't tell you when you have to stop this awful war game. So we can make a kind of analogy with the distinction between jus ad bellum and jus in bello, for those of you who like Latin sentences, because international humanitarian law does not deal with the start of an armed conflict. It does not deal with when a state can use force and violence against another state. That is a question that is covered by the United Nations Charter. And it's the same for ending an armed conflict. The Geneva Conventions have nothing to say about that. However, what I can tell you is that if belligerent parties would respect the Geneva Conventions, then I'm pretty sure that it would be much easier to get to the end of an armed conflict, to have peace and reconciliation.
So, Andrew, what do you think? What fuels these misconceptions? I'm sure you hear them all the time.
I do hear them all the time, and they make me very angry. But I don't think it's fair to blame my client, the Geneva Conventions. The Geneva Conventions don't create the misperception. So one of the worst things I saw written in a national newspaper was written by a former general who said, the Geneva Conventions entitle you to kill people. They contain the right to kill. Well, I've read the Geneva Conventions more than once, and there's no expression right to kill anywhere. The Geneva Conventions provide protection for prisoners of war, protection for civilians in occupied territory, and so on. Nowhere do they say you're entitled to kill this combatant. That is a misperception that people overlay onto them when they want to justify their behavior. And it goes to your charge that if something is not forbidden by the Geneva Conventions, they automatically authorize it. They don't. They prohibit a lot of other things. To give you an example of how misunderstood this is, people keep talking about the right to self-defense, but that's nothing to do with the Geneva Conventions. That's in the UN Charter. And people point to that and say, you see, we have the right to do these things. But the Geneva Conventions limit what you can do, and the right to self-defense should be limited. There's a misperception going on in the UN Charter as well. I'd like to see them in the dock. You'd say, no, you can't charge the UN Charter. It's great. Of course, it's the way people are interpreting it that's problematic. It's not the Charter itself.
You've set up our next conundrum. We'll get to New York next and we'll put the UN Charter on trial. But I'm wondering, what do you think actually fuels the conceptions. I mean, there's kind of a broad, oh yeah, people aren't educated, or journalists get it wrong, or, that stuff. But I think at the heart of it is that people would like some kind of fairness in the world system, and they're looking to blame somebody for it not being fair.
I'm afraid I'm much less charitable. I blame military actors who want to justify their killing. And the best way to do that is to say this is all authorized by the Geneva Conventions, as if there's somebody in Geneva sort of checking this off and saying, yes, that's all okay.
You're not doing that, Andrew.
I'm certainly not. I'm saying they require restraint. The UN Charter requires restraint. You can only do what is necessary and proportionate to defend yourself. You can't just say, oh, I've got the Geneva Conventions and the UN Charter. I'm entitled to self-defense. I can do whatever I want.
There's an enormous amount of training of armed forces around the world on the Geneva Conventions. I remember that was my first introduction to them in Nigeria, where I met a whole group of Swiss people who were training in the Nigerian army and were very shocked that this BBC journalist had no idea what the Geneva Conventions were, so they trained me too. But I'm just wondering whether you think that they do actually really engage on the substance, or are they just kind of ticking a box or just engaging at the edge?
No, I think that humanitarian actors are doing an amazing job in trying to disseminate the Geneva Conventions. You see the ICRC engaging with all the belligerent parties and trying to, train around international humanitarian law. You have other organizations like Geneva Call, which is also doing a very important work in disseminating IHL with non-state actors. We've not been talking a lot about non-state actors, but we know that there are a number of non-international armed conflicts, even more than international armed conflicts, and therefore that there are a multitude of organized armed groups which need to be trained, which need to be aware of the international humanitarian law organizations. And so, organizations like Geneva Call do that. So I don't think this is superficial. And it's not only the humanitarian actors having to do this, because it's an obligation, again, of states to disseminate IHL, and not only with the armed forces, but also with the civilians, with the population at large. So we are contributing today to the dissemination of IHL as well.
But I will meet you a bit halfway in that the problem with this training is if you say you mustn't kill civilians, you mustn't torture your prisoners, but everything else is okay, then it suggests killing soldiers on the other side, killing a rebel who's fast asleep, that all of that is okay because you haven't violated the Geneva Conventions. And so what I would appeal for is training which includes the UN Charter, which includes human rights, which says to the Russian soldiers, not just treat the prisoners of war well and treat the Ukrainian civilians well, but don't engage in a war of aggression. Don't kill people just because you've been told to. This is completely illegal. Now, that's sort of going beyond the Geneva Convention's humanitarian brief, but the problem is, as you've highlighted in your charge, that if we just leave it at the Geneva Conventions, it does rather suggest that everything else you do is permitted and authorized, and it's not. And that's where I think that the system breaks down. Geneva Call, the ICRC, they don't want to talk about that other stuff. And they leave the impression that it's okay to kill people, just don't kill the people who are protected by the Geneva Conventions. And as you can tell, I'm not in favor of killing anyone.
There's an awful lot of things that I always have to explain, that there's an awful lot of stuff that's kind of illegal under international law, but not criminalized. And the things that you can do in an armed conflict that don't land you in court are probably beyond the imagination of a lot of people. And so all these things, I'm sure you have the same, but I have had since the Russia, Ukraine and the Gaza conflict erupted again, I have the sense of being a virologist in COVID, where everybody now all of a sudden knows all about what is a war crime and what's not. And I see it go by on Twitter and I go, well, I don't know if this would end up in court. This is not the proof that you think it is.
You're absolutely right. It's a huge problem that everybody wants to reduce down the violations of international humanitarian law to war crimes. And that eliminates a lot of protection that we now don't talk about because everybody, journalists especially, will say, but is it a war crime? I can remember trying to present the situation in South Sudan. We had a 150-page report. And I got to the end of explaining it, and the journalist told me, yes, that's all fine, but is it a war crime? That's all they want to know. But they don't care that the humanitarian law is being violated on a massive scale. They just want the concept of a day in court for an individual. And that limits the impact of the Geneva Conventions. There's a set of principles which we haven't talked about called the principle of precaution, which means that you have to take precautionary measures before you target to decide what would be the risk to civilians. Now, failing to do that is not necessarily a war crime, but it's something we should all be stressing because that would lead to the elimination of a lot of unnecessary violence and a lot of suffering. But no, we all want to focus on what was the war crime, who got mistreated, when was there a direct targeting of a civilian, and so on. And we skip over most of the important protections, I'm afraid to say.
I fully agree, I have to say. And I would like to stress that the Geneva Conventions and the international humanitarian law is concerned first and foremost with state responsibility. With the 90s, we've started developing the international criminal law, also the development of the ICTY, ICTR, now the International Criminal Court. And therefore, there is this focus also in the media on war crimes and individual criminal responsibility. But that's just the tip of the iceberg. And we should be indeed more concerned with states, with their responsibility, how we can engage it, how we can put pressure. Because even if some people are being prosecuted, it does not mean that also there will be full reparations. So we have to put pressure on belligerent parties to stop, to halt the violations, to hold states accountable for that. And if you allow me, I would like to come back to what Andrew was saying before about the fact of killing in war, that killing also an enemy soldier is a problem. I mean, from a human rights law perspective, we think, okay, even soldiers have the right to life, and that is quite vital. And this is indeed fundamental. But at the same time, international humanitarian law is there to provide some minimal guarantees. And it is there to provide rules that you can respect and still win a war. So unfortunately, I want to be pragmatic and realistic. And I don't think that we can convince states when they are in the middle of a war that they shall not kill enemy soldiers. So I think that this is beautiful, but perhaps it's not for our world.
At the end of our podcast, we always have a traditional way of ending, but this time we're going to mix it up a bit. We'll come back to the traditional ending in a moment. This time we want to ask those listening to give us their feedback. And of course, that means you listening to the podcast. And we'd be very happy to hear back from you what you make of it all. But here in the room, we have a volunteer judge, someone who's been listening along. You've already heard his voice. It's Francesco Romani. Francesco, just to give what it says on the website about you, already have a PhD in international law from, I wonder where, the Graduate Institute of Geneva. And during his doctoral studies, he's been in Michigan and he's been in Harvard Law School. So he's been around a bit. So Francesco, let me invite you to join us at the big boys table here and take the microphone. Okay, Francesco, before we ask you for your verdict on everything, why don't you tell us, how do you think these professors did? Were they convincing? Did they argue well?
Fairly well, as you might see from the judgment that I will deliver in a moment. I think those arguments have been very convincing, and I hope I'll elaborate on them a little bit in the next few minutes.
Stephanie's going to remind you of the three counts. I just wanted to read out something from an article I read this week, and just to ask you for your reaction to this. Quote, "The hospital's chief medical officer grunts at any suggestion that X country might follow the Geneva Conventions, which forbid targeting medical units. Quote, they don't even know what it means, he says. And this country now tells its medics to remove any markings that might set them apart. Quote, if you put a red emblem on a car, you'll be fired on within 15 minutes. This is the reality of the world. The Geneva Conventions are not being followed by the other side, whoever that is. You don't need to know which conflict this is. It could be any of them that's going on. Does that worry you as a scholar in this area?
It does, in a sense, but I think it also gives hope in another, perhaps counterintuitive way. It is worrying because it points to certain tensions and difficulties that exist in the current legal architecture for the governance of armed conflict, But it also points to a circumstance that we should not underestimate. And the thing is that even nowadays, parties to armed conflict use the language of the 1949 Geneva Conventions and other IHL treaties to articulate their legal position vis-à-vis belligerent conduct. That is to say that even though there might be difficulties in interpreting and implementing the Geneva Conventions, among other treaties, they still provide a necessary point of departure for justifying and determining the legality of conflict nowadays. It is something that belligerents cannot escape when they argue about the justification of their conduct in warfare. So under that sense, they would still be an element to consider for all parties to armed conflict that have to justify their conduct. So they are still being seen by all belligerents, whether they're states or non-state armed groups, as something that cannot be dismissed in a very easy way. In that sense, there's still a beacon of hope even in the darkest times.
Yeah, I mean, that's why we're making the podcast. So, Steph, why don't you give us a reminder of the 3 counts?
Count 1, failure to protect victims of current armed conflict. Mr. Judge, how do you find?
The tribunal has very carefully considered the charges against the 1949 Geneva Conventions and has also listened very carefully to the arguments raised by the Defense Counsel. And on this charge, the tribunal has concluded that the Geneva Conventions are not guilty because they have not committed the facts that are brought against them. One thing that should not be underestimated is the fact that even though most of the times we read in the news about violations of IHL, there are a number of situations where actually IHL rules, including most notably those in the Geneva Conventions, are actually complied with by parties to armed conflict. There are a number of situations, for instance, where prisoners of war are treated humanely and released at the cessation of the hostilities. There are a number of situations where wounded and sick members of the armed forces are not killed or left to die, but actually taken care of by the party in whose power they are. And there are also situations where occupying powers provide food and medical supplies to the population of the territory that they are occupying. So this is one element, I think, that should not be underestimated when we talk about compliance with the Geneva Conventions. And secondly, one thing that perhaps was not brought about even by the Defense Counsel is the fact that since the very beginning, the Geneva Conventions were drafted as a compromise between military necessity and humanitarian considerations. So when we take that into account, we should not think that states cannot comply with IHL rules, because since the very beginning, they are seen as a realistic and viable way of behaving during warfare. So as was being said, states have a duty to interpret the Geneva Conventions in good faith. Parties to armed conflict must comply with IHR rules, and not only during warfare, but also to some extent during peacetime, through the adoption of military manuals, through legal trainings, through the use of legal advisors during their military operations. And also, as was said, third states might also have an obligation to ensure respect with IHL by parties to conflict.
We're going to read out count 2, and I'm going to ask you to give me the summary of the ruling in this case. Count 2, failure to meet the challenges posed by the contemporary and future armed conflicts.
Also on count 2, the tribunal has concluded that the 1949 Geneva Conventions are not guilty, but this time on the grounds that the facts do not subsist. So when it comes to count 2, I would just like to point to another argument that might be considered, and that's the fact that there might be one circumstance that we must consider when we look at the Geneva Conventions and their relevance nowadays, both for current and for future conflicts. And that's the fact that whenever a new state is created, one of their very first actions is to accede to the Geneva Conventions. That occurred after the decolonization process, once more at the end of the Cold War. But we've also seen new states in the year 2000s that took this very important step of becoming a party to the Geneva Conventions, even if those treaties date back to now 75 years.
Count 3, complicity in the misconception of international humanitarian law. How do you find?
The tribunal has found that the Geneva Conventions cannot be considered as guilty under this count either. The tribunal subscribes in large part to the arguments that were raised by the Defense Counsel, but we shouldn't lose sight of some very important developments that we're seeing nowadays. We have seen, for instance, that the International Humanitarian Fact-Finding Commission, which is one of the bodies established under Article 90 of the first additional protocol to the Geneva Conventions, might be taking action after a moment of sleeping, as it was being said by a famous scholar, Fritz Kalsoven. So it's a news of these past few weeks that there might be some further action by this very important enforcement mechanism.
Well, I want to say thank you very much, Francesco, for preparing and really thinking about all of these things. So really
My
appreciate
pleasure,
it.
and thanks to you.
So, as usual, at the end of our podcast, and this has been a bit of an unusual one, we've recorded it with a special technical help. So thank you very much for that. In, as you say, the extraordinary space here in Geneva, we've been allowed to be in this wonderful room, and with, as usual, with a couple of amazing experts who've completely batted away all of our questions and said, yeah, must be joking. But we always try to end with asking a couple of basic questions. And the first one is there a particular court case, we being the kind of journalists who deal with court things, basically in The Hague, do you have a favourite case? You've already mentioned Tadic yourself, Gloria, but do you have a case that you always come back to, that you're always referring to, that you're always saying students, you should remember this? Maybe it's a bad one, maybe it's a good one.
Yes, for international humanitarian law, I have to say the Tadic case is the one that you cannot avoid, because it's the first time the ICTY really discussed the possibility of having war crimes in a non-international armed conflict. It developed new criteria for the classification of armed conflicts and also for state responsibility. So using the test of overall control, saying that if a state has an overall control over an organized armed group, and that this organized armed group is fighting against another state, then all of this is an international armed conflict. So yes, I would say that Tadic is the case that you cannot avoid. Otherwise, I like also the case Nicaragua versus the US.
We hear that a lot, yes.
From the International Court of Justice. And I have to say, I had a professor of international law who was called Professor Luigi Condorelli. And I learned initially international law with Condorelli. And we spent, I think, at least 3 or 4 months discussing the Nicaragua case, because everything is in it, really.
Before we move to Andrew with this question, we're going to slightly Stefapedia you. ICTY, of course, is the International Criminal Tribunal for the former Yugoslavia, and the Tadic case is the case against Duško Tadic. It's the first case that the ICTY had against a Bosnian Serb camp guard, and all the kind of basic questions about what kind of conflict is this, can we actually have this tribunal, were all the kind of questions the judges had to resolve. Now, Andrew, I can see you thinking over there.
Thank you. I am thinking. Of course, I was going to had a whole speech prepared about Nicaragua and why it's so important, but we clearly need to move on.
We can also have an odd case or something that
I'll give you a case, I promise. But it won't be a Hague case. It's going to be the case of Osman against the United Kingdom. And it was the first case that I worked on as a lawyer. And at the time, it was quite strategic in that it's a case about private violence and whether private violence should come under the rubric of human rights and whether it comes within the European Convention on Human Rights. And part of our aim was to ensure that domestic violence cases would be treated as human rights cases. Because in those days, it was considered that private violence or domestic violence was not a human rights matter. It was human rights if a man was beaten up in a police station, but if a woman was beaten up by her husband, that's not a human rights question, because the state is not involved, and that's not how Amnesty International works on prisoners of conscience and so on. And so this was a case which was designed to protect people from private violence and consider it a human rights matter. And the reason it sort of popped into my mind just now is that I was watching TV recently, and there's a British cop show, and somebody was in danger, and the cop said, we're going to put an Osman notice on this.
Is that like the Miranda rights kind of?
Exactly. So it's a thing, that there's a procedure now that if somebody is at danger of private violence, then the police are notified. And Mrs. Osman notified the police that she thought her son was in danger. and the police did nothing. And unfortunately, then there was a death. And so the idea is once the police are on notice, they have to give special protection to someone. And so I feel that it's a case and it's interesting to read, but it's also a case that's had reverberating effects, to coin a phrase.
And our final question is there something that you've been reading, listening to, or watching recently? Maybe the name of that cop show, because if that's what you've been on your Netflix queue, that you would like to share with our audience. It can be something in this field that you think people should be reading, or it can be whatever you use to get away from it. You start, Andrew.
I have finished a book recently, which I think your listeners might enjoy. It's a book called Why War? And it's a book by Richard Overy, and it's very readable. And he goes through all the different theories as to why states and bodies and peoples go to war. And it's quite scientific. He tests it against various databases and so on. And I found it a great read. And so that's the one I'm going to leave you with.
Gloria.
Yeah, since we had the Geneva Academy, I would like to mention a new report that was produced by the Geneva Academy, a spot report in the framework of the project IHL in Focus, which is on the issue of sieges, the tactics of sieges that are being used in many armed conflict situations, and the food insecurity that derives from these tactics, which unfortunately are not completely outlawed by IHL. So we could accuse the Geneva Conventions of not prohibiting sieges appropriately. So I think this is a very interesting report looking at different armed conflict situations and showing also the risk of spillover of these tactics and of creating food insecurity beyond the borders of the countries which are at war.
Andrew, I saw you wanted to add something.
Well, just because you were inquiring into my TV viewing habits and you were trying to get to me to reveal the horrific TV that I watch, which is very lowbrow. And I was watching a show which your listeners will know called Hawaii Five-0 this week. And I was feeling guilty for watching it. But at one point in this most recent episode, there is a man who has a grudge against the United States military, and he decides to booby trap, I suppose is the best expression, a series of counters that you wear when you're jogging with little bits of explosive. And these counters are to be tied to the shoes of the marathon runners in this veterans race. And you see him doing this, and you see exactly how he does it. He puts a small bit of explosive inside of these gadgets. And then just as the race is about to start, he presses the button, and you see people's feet getting blown off, unfortunately, and damaged. And I looked at the sort of date of this, and indeed it's 2021, this episode. But I think, unfortunately, people do tend to get inspired by some of these. I'm not suggesting in this case anyone was particularly inspired, but you can see how some of these ideas are particularly dangerous in that they circulate, and so everybody gets their ideas from somewhere. And I do feel we need to be thinking more about censoring not just video games, but the way in which TV cop shows show that torture and intimidation is a good way to get information. I know Marco Sassoli and the Academy did a very good project on video games where they tried to encourage the makers to suggest that you lose points if you violate the Geneva Conventions in your game rather than getting points for killing somebody in violation of the Geneva Conventions. So the Geneva Conventions indeed have new frontiers to explore.
Absolutely. I have this at home. I have a 15-year-old who likes to game, but of course his mother has an international law and war crimes podcast. So I have come home to a son screaming at the screen, "This is a war crime. You can't do this." and I don't think that, but killing zombies, then the question is a zombie an enemy combatant, or if you're already dead, does IHL apply?
I think Gustave Moignet, who's looking down at us in his study, would say respect for the dead is also covered by the Geneva Conventions.
Even respect for zombies. I would like to say thank you very much to the Geneva Academy for extending their hand across a couple of countries to The Hague and inviting us here to this hallowed ground to where we hope we haven't desecrated it by asking some very basic questions about the Geneva Conventions. Thank you very much to them for doing that. Thank you to our guests so much for allowing yourselves to be put on you weren't put on trial, but maybe your world in some sense was. And I mean, really, God, the verdict wasn't a big surprise, was it? I mean, we knew it was cooked up before, wasn't it, Steph? We knew what they were going to say.
Well, I mean, they can hardly say anything else in this place, but they made some very good points. So I must begrudgingly admit that maybe not all of our charges are entirely true.
Dang. But anyway, thank you very much for playing along with us.
Thank you.
Thank you.
This was Asymmetrical Haircuts, your international justice podcast, created and presented by Janet Anderson and Stephanie van den Berg, in partnership with the Hague Humanity Hub. Music is by Autonautics.com. You can find show notes and everything about the podcast on asymmetricalhaircuts.com. This show is available on every major podcast service, so please subscribe, give us a rating, and spread the word.